स्वागत है आप सभी का मेरे YouTube चैनल पे। आज हम लोग ऑनरेबल सुप्रीम कोर्ट की एक वीडियो देखने जा रहे हैं। तो चलिए देखते कि इस वीडियो से हम लोगों को क्या क्या सीखने को मिलता है और इस वीडियो में हम लोगों को क्या क्या देखने को मिलता है।
Yet, the next day, Union Carbide said through their council, I have the documents on record. Union Carbide said that through their council that this court has no jurisdiction over us. They had a internal report which says that methyl isocyanate, once inhaled, only causes permanent injury if you have been in it for, say, a few hours. Petitioners 2 to 6, my lords, that where we are the victims, and orders have already been passed in 2011. My lords, what they are saying, there are 7 organizations altogether that represent all the victims. There are no other organizations. So we, my lords, are for 5 organizations. The impleadment has happened. We are now parties. So, my lords, what they are saying.
By which order were you made parties in this case?
By 13/4/2011. My lords, they are saying, if I may just finish, then of course you have your chance.
Very specific.
Yes,
in
sir.
the curative petition,
My lords,
who is the party?
in the curative petition, I am a party. But it's been allowed, and then it has been said that on maintainability and merits, we will be heard.
We will not.
Lords, if I may briefly
Please see the revised
respond to
order.
this point, beginning with the order, I'll read it out, my lord.
Read the
It
revised.
says, I didn't interrupt, so if I may have just a couple of minutes. Interlocutory application numbers 7 to 9, these are mine, are allowed subject to service. Subsequent to that, it says, issue notice on the maintainability of the interlocutory applications and merits of the matter.
Because
So, my lords, the hearing that happened then, and in fact, in a lighter note, the Chief Justice was representing us in the criminal curative petition. Our interlocutory applications were allowed. And what was said was that subject to maintainability and merits of the matter. Because it was recognized, my lords, that these are inextricable. My lords, we had filed an application for impleadment pursuant to the right given in Charan Lal Sahu, which is a 5-judge bench. They had looked at the Bhopal Gas Claims Act, Section 4, and they had said that, look, we can't make up for the fact. I mean, we can't unravel the settlement to the extent that you weren't heard prior. So now that's all done as water under the bridge. But now you must be heard. And what it says, and I quote, in order to make the opportunity contemplated by Section 4 of the Act meaningful and effective, it should be so read that the victims have to be given an opportunity of making their representation before the court comes to any conclusion. In addition, Section 4 says the central government shall have due regard to any matters which such person may be required to be urged. Now that the learned Attorney General has made such a heartening statement, we are deeply hopeful that they will have due regard to our pleadings as petitioners 2 to 6. But my lords, regardless, we have our claims before the court. My lords, there are 2 aspects of the review, as one of my friends very fairly pointed out. They said that, and this might narrow the issues a little bit, they said that there is the civil aspect, which is the $470 million, and then there is the criminal aspect, which was initially quashed. And then their counsel invited the jurisdiction of this court explicitly under Article 142, citing the Sanchita set of judgments, in order to say, please support, please continue the withdrawal/quashing of the cases. This court considered that issue and said, no, we are not doing this on the basis of a public policy. We are saying because in this case, the matter must be investigated. Not in any regard did they say that this is without prejudice to the argument that they are not submitting to the jurisdiction of their court. And yet, the next day, Union Carbide said through their counsel, I have the documents on record. Union Carbide said that through their counsel that this court has no jurisdiction over us with regard to the criminal cases. 4 months later, and we have that on record, the criminal court concerned, the jurisdictional criminal court, declared them a proclaimed offender under Section 82. To this day, they are absconding. It is recorded in the final judgment against UCIL. And so with regard to the second part, my lords, there's no more delicate way to put it. We believe that they have played a fraud on the court. There was an order that was placed after that with regard to attachment, my lords, of their properties. What they did, and these are not my words, these are the words of a district court in Connecticut, a federal judge in Connecticut, their country, said that the admitted facts are that after the Bhopal gas disaster, they set up a web of intermediaries in order to bring their goods into the country. My lords, with regard to the settlement itself in 2009 and 10, through the process of RTI, but also the US discovery process, which is quite rigorous, and they're on pain of criminal penalties, documents can't be suppressed, etc. Documents were discovered showing that they had an internal report which says that methyl isocyanate, once inhaled, only causes permanent injury if you have been in it for, say, a few hours. They had proposed, and this is the basis of the settlement is a top secret document, and I quote, it says top secret right on top, with the government at the time, which proposed categories of temporary injury and permanent injury, and over 98% of the claimants have got under temporary injury on average of 25,000 rupees, whereas they knew that the injury is most likely in all cases to be permanent, and that was suppressed. How are we arguing suppression? And this all we will place, my lords. We are saying that they suppressed it on the basis that they told the Environmental Protection Agency that this is a trade secret. We are required by law to give you these documents. Please do not disclose them further. But the Environmental Protection Agency decided otherwise. So, my lords, a recent 22 judgment, but all the way down from Chengalwada, as my lords are aware, fraud must unravel a judgment, cannot sustain. And my lords, we'll explain that 2004, not 2002, 2004, the curative jurisdiction arose and why we are coming in 2010.
Well,
तो जैसा कि हम लोग यहाँ पे देख सकते हैं कि यहाँ पर अपनी वीडियो ख़त्म होती है। इसमें जो लेडी लॉयर थी, जो लेडी एडवोकेट थी, उन्होंने आर्ग्यूमेंट दिया था भोपाल गैस डिज़ास्टर जो हुआ था अपने देश में उसको लेकर के। उन्होंने ये कहा था अपने आर्ग्यूमेंट में कि जो विक्टिम्स थे भोपाल गैस डिज़ास्टर के, उनको जो कंपनसेशन मिला था वो इनफ नहीं था, उन्हें और कंपनसेशन मिलना चाहिए। मैं उम्मीद करता हूँ कि आप लोगों को वीडियो पसंद आई होगी। अगर वीडियो पसंद आई है तो प्लीज़ लाइक और कमेंट ज़रूर करें, और अगर आप ऐसे ही वीडियोज़ रेगुलरली देखना चाहते हैं तो प्लीज़ मेरे चैनल को सब्सक्राइब कर दें।